Fani Willis hires disgraced ex-judge as prosecutor. Fulton County is the revolving door that nobody asked for. Or maybe the revolving hallway, because I'm pretty sure the courthouse and district attorney's office, they're in like the same building, separated by a hallway. Anyway, this is from the Atlanta Journal-Constitution, written by Rosie Mannins. Shermela Williams resigned as a Fulton County Superior Court judge in February while facing possible removal from the bench for professional conduct violations. A former Fulton County Superior Court judge accused by Georgia's judicial watchdog of breaking the law by jailing a young woman has been hired by District Attorney Fani Willis as a prosecutor. Now, she used to be a prosecutor. A lot of judges used to be prosecutors. Not every day that I hear a story about a judge resigning to become a prosecutor and that cause of resignation being tied to an investigation into misconduct and possible fear of reprimand. So Shermela Williams resigned in February while facing possible removal from the bench over a series of misconduct charges and an associated lawsuit. Now Williams, a judge since the start of 2021, is returning to the Fulton County District Attorney's Office, where she previously spent several years as a prosecutor. A spokesperson for Willis's office told the AJC that Williams is an accomplished attorney who has served before with distinction. We are fortunate that she's bringing her experience and knowledge back to our office to serve our mission of making Fulton County a safer, more just place for everyone, the spokesperson said Monday. Williams did not respond Monday to questions about her new role. The DA's office declined to disclose comments on the salary.
I heard you all got raises. Yeah. Was there not some bonuses? Bonuses.
Williams' job history shows she was a senior assistant district attorney in Fulton County from 2011 to 2014, when Willis was also a prosecutor in that office. Williams then spent a couple of years as a prosecutor in DeKalb County before working as a litigator at Atlanta law firm Thomas Kennedy Sampson and Tompkins. As a judge, Williams was the target of a misconduct investigation, and we're going to get into the background on that, by the Georgia Judicial Qualifications Commission, at one time charged with more than 30 counts of violating the Georgia Code of Judicial Conduct. The JQC's hearing panel recommended last year that Williams be ousted from office, saying she'd inexcusably broken the law by jailing a young woman called to testify in her parents' divorce hearing. Williams said she wanted to teach the 21-year-old a lesson and understands the way she handled the situation was wrong. The woman, Molly Dennis, sued Williams in October, alleging her constitutional rights were violated when she was placed in a courthouse cell for up to 45 minutes on Williams' orders. Williams recently sought to end the lawsuit, arguing she has absolute judicial immunity against Dennis's claims. The jailing of Dennis in 2023 was the worst of several missteps by Williams, the watchdog JQC said. And again, this is going before the state Supreme Court, so Georgia Supreme Court, they'll be the ones that ultimately weigh in on what to do with this decision. The JQC added that it was disappointed in Williams' stunning lack of candor throughout the misconduct case. We're going to see that. Williams' resignation came before the state Supreme Court decided what, if any, punishment she should face. The JQC has asked the court to consider penalizing Williams irrespective of her resignation. The court has the authority to temporarily bar ousted judges from seeking judicial office in the future, among other things. JQC Director Courtney Veal said Williams' resignation was an obvious attempt to resign her way out of accountability for her misconduct, though it was certainly best for Georgia's citizens and judiciary. Well, I wonder if this statement was made before she stepped back into a public service position at the prosecutor's office. The resignation, but wait, there's more. Before resigning, Williams had urged the state Supreme Court to let her stay on the bench, suggesting a short suspension would be adequate punishment. In her resignation letter to Governor Brian Kemp, Williams said her decision to step down was bittersweet. She was elected to a second term last year. Serving in this role has been one of the greatest honors of my professional life, she wrote, both in and out of the courtroom. I have proudly served my community with diligence, respect, honor, balance, and impartiality. Williams is also accused in the JQC's misconduct case of improperly favoring a Delta Sigma Theta sorority sister in a child custody case and making other litigants in family cases wait up to 2.5 years for rulings. And so that's the update today. We hear that there's this hiring decision by the Fulton County District Attorney's Office of previously Fulton County Superior Court Judge Shermela Williams, who seems like she resigned before whatever reprimand, if any, came down from the Georgia State Supreme Court. And I think one of the most important things to keep in mind is that prosecutors are licensed attorneys. They have a duty of candor to the court. And Andrew Fleischman here, who I initially saw share this story this morning, says it better than I could explain. He's an attorney himself. The JQC report about Shermela Williams shows that she violated her duties not just as a judge, but as a lawyer. She lied repeatedly to the tribunal. That's Rule 3.3 and 8.4. She locked up a witness for no reason. That's Rule 4.4. She discussed cases ex parte, violating 3.5. And in his opinion, the Supreme Court of Georgia is still weighing whether to disqualify her as a judge after these findings, but it seems obvious that she should be referred to the state bar for discipline. So imagine the Supreme Court of Georgia issues some finding where, it impacts her law license through some type of suspension, or who knows. Well, I think this impacts his hiring decision. And that's the summary of what happened today. So if that's all you needed, hit that like button. Thanks for tuning in. We're going to also look, before we end this video, at this recommendation from the JQC that they released last fall and that the Supreme Court still has in front of them. The state Supreme Court still has in front of them. So we're going to jump around. I'll link the full thing in the description in case you want to go all the way through it. But some quick background here on the context of what constitutes count 4 and 5 of the misconduct claims. Personal call on behalf of uncle. So this is all about Judge Shermela Williams. A domestic contempt case was filed in Fulton County Superior Court. The plaintiff was represented by Patricia Shoemaker and Bonnie Stinson of Shoemaker and Lewis. The defendant represented himself. The defendant's going to end up being her relative, her uncle. This case was not assigned to Judge Williams, but rather to another colleague in the family division, Judge Kevin Farmer. The defendant in this case, Corey Hill, is Judge Williams' uncle. On April 22, 2024, shortly after the case was filed, Judge Williams called Shoemaker and Lewis. So calling the attorney for the plaintiff. Shermela Williams' uncle is the defendant, and she's calling the attorneys for the plaintiff. And asked to speak only with Bonnie Stinson, the junior associate listed on the pleadings in her uncle's case. The footnote here says, of particular concern, this telephone call was made while Shoemaker and Lewis had at least one pending case before Judge Williams, and after she knew that she was under investigation by the JQC for much, if not all, of the previously discussed allegations of misconduct. Ms. Stinson was in court, and a message was left by the judge with the firm's receptionist requesting that Ms. Stinson call the judge after hours on the judge's personal cell phone. Ms. Stinson, who was licensed to practice law in 2022, so new lawyer, felt extremely uncomfortable when she viewed the message. She explained, we currently had a case pending in front of Judge Williams, and I didn't see a reason why she'd be contacting me alone. She immediately told her supervising partner, Ms. Shoemaker, of the call and showed her the message. Neither of them knew a reason why the judge would call asking to speak only with Ms. Stinson, and given the somewhat unusual nature of the call, Ms. Stinson wondered if it might be regarding an offer of employment with the judge. Ms. Stinson waited until after 5 p.m. as instructed by the judge and returned the call to the judge's cell phone. A member of the judge's staff answered and took a message as the judge was still in court. The call was returned by Judge Williams later that evening. Judge Williams began the call by stating, it was Judge Williams, but then quickly went into that she was not calling me and trying to use her capacity in office and title to try to influence me in any way. And this is important because if you're doing something not as a judge, then you lose the umbrella of absolute judicial immunity. She said that she was calling in her personal capacity on behalf of her uncle, who was the opposing party in Ms. Stinson's case. According to Ms. Stinson, whose testimony we credit fully, so they found her credible, Judge Williams immediately launched into the merits of the case, which prompted Ms. Stinson to ask several times if the judge was representing her uncle. Ms. Stinson testified to the following. She began advocating for her uncle. She mentioned that if this case had gone in front of her, that she would have dismissed it, that there doesn't seem to be any benefits available, and that we should just figure a way to make this all go away, and that I was a reasonable attorney, and that attorneys at my firm were known to be reasonable attorneys, and that there should be a way that we could just figure this out instead of having the case go forward. Ms. Stinson stated the call lasted some 45 minutes, with the judge talking for about 30 of the 45 minutes. During the call, Judge Williams told Ms. Stinson it was her understanding that there were no GI benefits, and that's what she was advocating for, that the case should go away. While the judge did not directly order her to dismiss the case, Ms. Stinson said it was strongly emphasized that it was an impossible case, and that she would have dismissed it if it had come before her. She also requested an extension on her uncle's behalf, and Ms. Stinson told Judge Williams that her uncle would need to make that request herself in writing directly to the assigned judge. Ms. Stinson remained very uncomfortable throughout the call and attempted to be polite and diplomatic because she has a different case in front of the same judge, but as non-committal as she could. Ms. Stinson had a case in front of Judge Williams at the time of the call that had been to a final hearing about a month prior and was awaiting a final order on the judge's pronounced oral ruling. However, the parties had requested time for additional briefing, which was granted. Yeah, that's a crazy detail there. It's pressure. 2 days later, on April 24th, 2024, Ms. Stinson received an email purportedly written by Judge Williams' uncle. It was Ms. Stinson's belief, and is likewise ours, that the uncle is not the author of the email. Ms. Stinson noted that the subject line of the email used Superior Court case identifiers and terminology that pro se parties typically do not use. She also found the tone of the email to be incredibly formal. So an example given was, "Nonetheless, I am not challenging service," and "sophisticated, even for an intelligent pro se party." Importantly, we note that the subject line also contains FW, suggesting that the uncle had forwarded the email from someone else or from some other email account to Ms. Stinson. That reminds me, was it Shannon Sharp who released a statement, but he left it as sent by his team to him? Anyway, in her answer to formal charges, Judge Williams admitted that she'd made the telephone call to Ms. Stinson. However, she denied that she asked for an extension, denied that she said the parties should work something out, denied she was told the uncle needed to file his own request for extension, and denied that she otherwise discussed the merits of the case. So that's her under oath testimony. She also disputed the material content of the telephone call when she first testified before us on May 21st, 2025. Judge Williams claimed a lack of recall on many of the director's questions. However, when posed the direct question, "During the call with Ms. Stinson, did you argue the merits of the petition to her?" she unequivocally answered, "No." When posed the direct question, "Did you tell Ms. Stinson that if a petition like that came before you, it would get dismissed?" she again unequivocally answered, "No." It was only after hearing Ms. Stinson testify on May 22nd, 2025, and after reviewing the transcript between hearing dates, that the judge then amended her testimony, changed her testimony, before us on June 27th, 2025, to more closely mirror what Ms. Stinson had previously said about the material portions of the call.
I want to next turn, Judge, if I can.
Yes.
To the complaint surrounding your uncle and Bonnie Stinson and the case in the call. You recall testifying that you should have never made that call?
Yep.
Do you understand why you shouldn't have made that call, Judge?
Yes.
And why is that?
Multiple reasons. One of the things that I've learned as a judge, even though it's not the way I operate, certainly I do understand that other people operate in this manner, that because you're the judge, people sometimes feel a sense of intimidation or a sense of compulsion, let me say it that way, to do certain things, right? So even in a laughing matter, there are some things that people say, and I'm like, nope, we don't even joke about it, right? So though I understand what my words were and what my intentions were, I understand how Ms. Stinson could have taken it differently. So that's one thing, right? The road to hell is paved with good intentions sometimes. And so it's just best to err on the side of not doing anything, right? So even in my personal life, there are things that I don't do because, as one of my mentors told me, you can never take the judge head off. So I don't.
Do you recall Bonnie Stinson's testimony whereby she said during the conversation that you had with her, you said if the case came before me, you would dismiss it? Do you recall her testimony in that regard?
I don't recall those being her exact words, but I recall that sentiment. Okay. Yes.
Do you recall, as you sit here today, making that statement to Bonnie Stinson?
I don't recall making that exact statement, but I do recall saying that if what he's saying is true, then the case would probably be dismissed or something like that, that again, she could have taken to be those exact words. Okay. I don't recall what the exact words were.
Did Ms. Stinson, okay, when she testified, did it refresh your recollection at all about what you exactly said? I think you've answered it, but I'm just going to ask you again.
I don't remember the exact words. I remember the sentiment. And part of that is I don't recall my exact words. What I do recall is saying something to the effect of, if what he's saying is true, then I don't see how there's a contempt or something like that. But I can't say that what she said were not my exact words, were my exact words. But I'm just telling you the sentiment and what I remember saying. I'm not saying that I did or did not, because I don't recall those words being said.
You have no reason at this point, based upon Ms. Stinson's testimony, to believe that she's making that up, though, do you?
No, that's what I'm saying. I do recall relaying those sentiments. I don't know if those are my exact words.
Okay.
Her new, but still decidedly vague answers on these topics are once again replete with, I'm not saying that I did or did not, or I don't recall my exact words, or other failed recollection answers. But they are now qualified by explaining, I remember the sentiment, and I do recall relaying those sentiments. I don't recall if those are my exact words. Her explanation for the blatant discrepancy in testimony from day 1 to day 5 seems primarily to blame the director for not providing a statement from Ms. Stinson in discovery, or a summary of what her testimony would be. So her explanation is, I couldn't see what she was going to say in advance to get my story straight before I first said what I testified to initially. She also attributes her lack of memory on the topic to her grandmother's death, which occurred during that time period. As the judge stated, I've been encapsulated by trauma for the last 3 years. We are sympathetic on this point. Yet, she has been able to recite in great detail her memory of other events from the same time, most of which are helpful to her. To go from unequivocally denying material portions of the conversation happened, to trying to clean up her testimony and now align it with an obviously credible witness, is troubling. This is compounded by the absurd exercise of getting her to admit that she wrote, or at least played a significant role in writing, the email sent by her uncle. On day 1 of the hearing, Judge Williams claimed that she had not even seen the email until it was served on her in discovery. When asked if she helped him write it, she responded, he wrote down what I said, but no, I did not help him write the email to that extent. But did he write down what I was telling him? Yes. To clarify, a panel member asked, so you didn't write it, but you told him what to write? Her answer, no, I didn't tell him what to write, and explained she simply told him about the call and that her assumption was that he was writing as she was talking. This left us with the impression, or more accurately, misimpression, that she had merely relayed her conversation with Miss Stinson and that her uncle was taking notes but formulated his own email. When it was pointed out by a panel member a few moments later that he writes like a lawyer, the judge responded that he was writing what I was saying. What I said is I didn't write this email. And then on day 5 of the hearing, Judge Williams' counsel asked, did you physically write the email? And her answer was no. He then asked, did you direct your uncle to what to put in that email? And her answer was now yes. She did not dispute that she helped her uncle in drafting the email and said, I told him what to write. I never denied that. This directly conflicts with what she previously said on day 1. She attempted to explain this by saying that after reviewing the transcript and talking to her lawyers, that she thought she had been clear that she dictated the email to him, the email she claimed not to have seen until discovery, and that she had in fact told him what to say and never denied that the words in the email were words that came from me. Now, I've got to pause here because now you're going back to the prosecution office. Fulton County, who has not had the most stellar reputation of prosecutions with integrity. This sounds like somebody who might think it's okay to coach a witness in the middle of their testimony. Like if court ends for the day and they come back tomorrow. Just, oh, it's okay, we gotta tighten up. We gotta make your testimony better. I don't love this. A panel member then pointed out, you told us you didn't write it. To which she responded, I didn't write it. She explained, I gave him the language. I told him what to write. I told him how to format it. I can tell you distinctively, specifically, I did not write it. Instead, even though the header said forward, the subject line said forward, instead, she agreed for the moment that she told him exactly what to say and he typed it in and read it back to her for approval. Though, when a panel member asked moments later if it was a fair assessment that she dictated it and he read it to her and she approved it before it was sent, she equivocated somewhat. For the most part, yes, but eventually tepidly agreed that was correct. We had to work very hard to ask exactly the right question in precisely the right way to get at the truth, the whole truth, and nothing but the truth. That is unfortunate. In summary, we find the call took place how it was described by Ms. Stinson, and that the email forwarded by Judge Williams' uncle was authored by Judge Williams. And then they put a footnote. Respondent testified, so Williams testified, that she knew Ms. Stinson and found her to be a credible attorney, known for always being really straight with the court. So, yeah, you think Stinson's credible too. And assured, the JQC says her lack of candor on these counts shows us that Judge Williams knew she had a duty to not take the action she took, yet she did so anyway, and she did it out of self-interest, to help a close family member, and ill will toward the opposing party in her uncle's suit. We further find Judge Williams acted with a dishonest purpose and conscious doing of wrong. We find by clear and convincing evidence that Judge Williams acted with more than negligence and that her conduct meets the standard for bad faith. And they find that her actions provide a constitutional basis for discipline on the ground that her conduct was prejudicial to the administration of justice, which brings the judicial office into disrepute. So we're going to look at the sanctions if you want to look at the background on the other counts that they considered and found that she had violated. Full document is linked in the description. This is really what the JQC is asking the Georgia State Supreme Court to consider on their recommendation regarding what they're classifying as willful misconduct in office by Judge Shermela Williams. The director of the JQC contends that Judge Shermela Williams' removal from office is the only appropriate sanction given the seriousness of the violations, the pattern of repeated misconduct, and her lack of candor. Judge Williams seeks something short of removal. Remember, this is back in October of 2025, so it's before her February resignation, although it is not entirely clear what alternative sanction she is seeking. Her counsel argued for a private reprimand up to and including a suspension of no greater than 30 days. Judge Williams testified that she believed that a private reprimand doesn't even make sense because the cat's out of the bag, right? Now imagine a criminal defendant saying this to a judge who, it's a sentencing hearing, and the defendant's like, "Can I speak, Your Honor? I want to speak before you sentence me." Punishing me doesn't even make sense because the cat's already out of the bag, right? Like, what? She suggested a public reprimand was the appropriate sanction, even though clearly this has been publicized everywhere. So functionally, I've already had that, right? Additionally, she asked that in lieu of a suspension, that we take into account the fact that she's been paying her own legal fees, and Mr. Banks and Ms. McFadden are not cheap. The purpose of the suspension is to impute a financial penalty to the judge. Well, I've endured that financial penalty. However, in her answers to formal charges on both cases, Judge Williams asked that all costs be assessed against the JQC. She clarified that those costs should be assessed against the director and the investigative panel and wants them to pay her legal fees because I'm here because the JQC has stayed steadfast to nope, removal is the only answer. Eventually, she landed on a public reprimand and the financial penalty she's already paid to her lawyers, in parentheses, as tantamount to a fine, so to speak. But if we were not inclined to agree, then no more than a 30-day suspension. And then there's a footnote. This begs the question, how many criminal defendants or civil litigants were given credit against any fine assessed by Judge Williams for payment of their legal fees? It's a ludicrous request. Like, basically, this footnote says that's not how this works. In making our recommendation, we turn to comment 6. Beginning with the seriousness of the transgressions, we find that they fall on a continuum. The illegal jailing of a witness is the most egregious. In a vacuum and viewed in context of her total caseload, the late rulings appear to be the least serious of the transgressions. However, to say that any of these transgressions are less serious than others should not be construed to suggest that they are not all serious in and of themselves. For example, we recognize that even though the late rulings were certainly a small percentage of her overall caseload, it does not mean that it was of little impact to the affected individuals. From a man who was hungry and homeless and could not get necessary medical treatment, to a mother who mightily struggled financially for almost 3 years awaiting a child support ruling, to a father whose entire relationship with his children for years was a single 10-minute FaceTime call per week, the consequences were significant and outsized. These parties were denied the certainty, stability, and relief they deserve from the judicial system. As for Molly Dennis, this is the woman who's suing. She was the one jailed and held in contempt. The outrageousness of Judge Williams' conduct speaks for itself. She broke the law in a way that is inexcusable and which has left an indelible impression upon Molly. If the public cannot trust the person who has taken an oath to uphold the law to actually do so, the public's perception of the judiciary as a competent, neutral, and equitable body is severely damaged. The improper ex parte call and using the prestige of her title to further her and her uncle's interests are also very serious. Both instances of misconduct erode public confidence in the impartiality and integrity of the judiciary. They leave the public with the image of a judge who allows personal, social, or family connections to influence her judgment and actions. In addition, as discussed previously and below, Judge Williams lied about what happened in both these instances. Next, we examine whether there's been a pattern of improper activity. There certainly has been in this case. The JQC investigative panel opened their first investigation of Judge Williams in February of 2022 concerning the improper ex parte call. Before that could be resolved, the investigative panel began its next investigation concerning multiple complaints of failures to timely rule, which the director wrote her about not once but twice. Then came the illegal jailing of Molly Dennis, and later, the improper use of her position on behalf of her uncle. These last two incidents occurred at times when she knew she was already under investigation by the JQC for the previous complaints, a time when most judges would be on their best behavior. This leads us to one of two equally concerning conclusions. Either she just did not care, or that was her best behavior. We also consider the impact of her improper activity on others and on the judicial system. It requires little effort to find that her improper conduct has had a substantial effect on every person involved with Judge Williams' acts and failures to act. Beginning with the late rulings, as mentioned above, the percentage of late rulings may have been small against the whole of her caseload, but to the litigants, the costs were immeasurable. Relief that is so late in coming was quite possibly no relief at all to those parties, and directly reduced the faith of those parties in the court system, and likely did the same for anyone with whom they shared their experiences. This creates a ripple effect that further reduces faith in the judiciary. Likewise, both the improper ex parte conversation and the inappropriate use of her position on behalf of her uncle erode public trust in the judicial system. These two incidents, in actuality and in appearance, demonstrate for the public a judge who moves behind the scenes and in secret to manipulate case outcomes. Now, is this somebody you want working as a prosecutor? Just saying. As for the illegal arrest of Molly Dennis, the ramifications are undeniable. Public trust in the judicial system is annihilated when judges do not comply with the law, and an individual's liberty is taken as a result. It cannot be put any more plainly than when Molly publicly said, "It just was reaffirmed to me that the justice system doesn't actually care about you as a person." And this is so rich, and if you missed the YSL case, the prosecutors in the YSL case got in trouble for a Brady violation, and they were ordered to take a course on Brady training. They had to do a Brady class. If you have evidence that may be exculpatory, disclose it to opposing counsel. Disclose it to the defense. Take a class on that, even though you should know that already. So what do we have here? This is the perfect fit for this prosecutor's office. In addition to the factors contemplated in the JQC rules, we also evaluate other mitigating and aggravating circumstances presented. Judge Williams' counsel highlights several factors in mitigation, including her lack of prior disciplinary history as a judge or a lawyer, her acknowledgement of misconduct and remorse. Well, the cat's out of the bag anyway. Is that really remorse? Her inexperience and growing pains as a new judge, her willingness to take corrective actions and additional training, her community support and re-election despite the pending formal charges, and her personal family circumstances. Taking these at face value, they each amount to some evidence of mitigation. However, a closer examination reveals that at least some of them are also not as meaningful as Judge Williams suggests. For example, the many hours of National Judicial College training that she presented in R6 and her willingness to attend future training as required, in case she's ever assigned to take a Brady class, appear mitigating on their face. We note, however, that many of the would-be helpful classes, such as mindfulness for judges, decision-making, and enhancing judicial bench skills, had already been attended by Judge Williams prior to at least two of the instances of misconduct here. They did not prevent the misconduct that occurred and do not provide us any level of comfort they will prevent future misconduct. Instead, they illustrate for us that this is simply not an issue of retraining. So again, is this someone you want as a prosecutor, that if something goes wrong, They can't even improve through training. Would a Brady class order work for somebody like this? They go on, they say, similarly, Judge Williams asserts that she has a lack of any disciplinary history with either the State Bar of Georgia or with the Judicial Qualifications Commission. That is a factor to consider and helpful for her generally, but does not take into account the fact that, though she's never been formally disciplined by the JQC, this is also not a case that presents a singular instance of misconduct before this body. Rather, there were multiple instances of misconduct which span the majority of her first term in office. Finally, she contends that she's accepted responsibility for most of the misconduct. This presents the murkiest of the mitigation evidence because it is still far from clear what Judge Williams has really admitted to, given that as readily as she admitted to certain violations, she just as quickly retracted them, even contradicting at times what her own lawyer stated on the record to us. And then the footnote here says, a truly bizarre example of this is her amended admissions and stipulations to formal charges that was presented on July 14th, 2025, so before the hearing. Though she couched it as being prepared at the hearing panel's request, it is a not-so-veiled attempt by Judge Williams, even after evidence was closed, to get the last word. As an initial matter, she'd be perfect for this prosecutor's office. You remember Love trying to get the last word? Oh, she would be perfect. As an initial matter, we merely asked the attorneys to clarify for us in closing arguments, this is italicized and underlined, where we stood on admissions. We did not ask for this document, which is fraught with problems. It is glaringly obvious that only Judge Williams signed this document, so her attorneys didn't even submit this. She went and submitted this. It says neither of her attorneys did, as doing so would contradict the previous representations that they made as officers of the court. Don't do that to Gabe Banks. The director certainly was not invited to review or sign it, despite the fact that it negates their previous stipulations and attempts to bind her to the new ones. The only clarification this document provides is that we are correct in our credibility assessment of Judge Williams. Yeah, and this to me, doing this, and then during the hearing, doing the back and forth over whether or not you wrote this email that the uncle submitted with forward in the subject line still. Anyway, back to the writing. This confusion was created by nobody but her. She wishes to appear cooperative and receive the benefit of admitting, I am admitting my wrong, I am taking responsibility, and I tried to take responsibility from day one. But when you're told the only thing that's on the table for you is removal, I don't have a choice but to come to you all. But she also wants us to ignore her other words and actions throughout this entire process that indicate otherwise, starting with how she behaved when she received her first complaint. The director asked, do you remember calling the main line of the JQC, speaking to Miss Birch, and immediately saying, this is BS? Judge Williams admitted, I probably did. So they say the director and Judge Williams both urge us to look at recent decisions for guidance, and they've identified those which they each contend are the most similar to this matter. Judge Williams offers inquiry concerning Norris as the most similar from 2022, as the most similar, and insists it is on all fours with this case. While it is true that her case and the Norris case bears some similarities, they are not identical. The case before us involves a witness being needlessly humiliated, handcuffed, and placed in a holding cell for a period of 15 to 45 minutes based on a directive from the judge. The citizen in Norris endured a similar and humiliating berating from the judge, felt as though he was not free to leave, was told no when he asked to leave, and an armed deputy was standing at the door to the judge's office. However, he was never physically placed in handcuffs, escorted from the courtroom, and locked in a jail cell. Moreover, the illegal jailing, albeit the worst misconduct alleged, is not all that has been alleged and now proven here. Perhaps if our illegal jailing incident existed in isolation, a different result might follow. It does not. Here, there's been a pattern of misconduct alleged and proven by the director. The director asserts that this case much more closely aligns with the multiple CJC violations and evasive, disingenuous, and dishonest testimony displayed in the inquiry concerning Judge Christina Peterson, this looks like, 2024. We agree. Aside from the proven misconduct, what is equally, if not more distressing, is Judge Williams' sometimes outright dishonesty and other times evolving testimony during these proceedings. Judge Williams gave false testimony regarding some allegations and was evasive and deceitful on others. We should not have to ask questions multiple times or ask the exact right question to get an accurate, clear, and complete answer. Moreover, she should not have to clean up her testimony between hearing sessions to make it sound better after an adverse witness testifies. Of all the witnesses who come before us, the one who is expected to be the most forthright and the most candid is the judge. In the matter before us, unfortunately, that was not the case. Coomer 2 provides us with our North Star on this particular issue, the guiding light. The rule of law depends on such public trust. We do not expect judges to be perfect. Judges are human. But we can and do expect them to be honest. And this is bolded. The judiciary has no place for dishonest persons. And public confidence that judges are honest is particularly important given the place of the judiciary in our system of government. The judiciary's authority depends in large measure on the public's willingness to respect and follow its decisions. As Justice Frankfurter once put it, justice must satisfy the appearance of justice. We do not expect Judge Williams to be perfect. However, we did expect her to be honest during her testimony to us. On that front, Judge Williams fell woefully short. As discussed throughout this recommendation, Judge Williams' answers evolved throughout the hearing, depending on what answer she believed helped her defense the most. At times, her responses were incomplete and required intense, probing questions by us in order to obtain a clear picture of what had actually transpired. Her stunning lack of candor to us was disappointing, if not unsettling, to say the least, as we hold judges to a higher standard. Given the level of untruthful testimony Judge Williams offered throughout, we are left with little option but to seek the ultimate sanction of removal. A judge that cannot be trusted to tell the truth cannot be trusted to remain in office. We have approached our task with the solemnity and seriousness that is due. We do not take this responsibility lightly and do not make this recommendation without the full knowledge of what this means for Judge Williams personally and professionally. Yeah. We're giving you a golden ticket to get hired by the prosecution office. Little did we know. However, the object of proceedings such as this one is not to punish the individual judge, but to maintain the honor and dignity of the judiciary and the proper administration of justice. As our Supreme Court has explained, the judiciary's judgment will be obeyed only so long as the public respects it, and that respect will not long survive judges who act in a manner that undermines public confidence in their judgment and integrity. And that's from Coomer. We unanimously recommend that Shermela J. Williams be removed from her position as Fulton County Superior Court Judge. Upon the filing of this report and recommendation, the director shall transmit the record to the Supreme Court of Georgia. And again, this was October 2025, October 2nd, 2025. So to round this one back out, I want to circle back to today's AJC article with the statement from Fani Willis's office. Just bring it full circle here. Now that we've read a little bit of the context, why there was this resignation, what's still in the air for the Georgia Supreme Court to have to settle out, if they choose to settle it out, regardless of the resignation. Let's just read this statement one more time. A spokesperson for Willis's office told the Atlanta Journal-Constitution that Williams is an accomplished attorney who had served before with distinction. We are fortunate that she is bringing her experience and knowledge back to our office to serve our mission of making Fulton County a safer, more just place for everyone, the spokesperson said Monday. So, leave that information with you. That's the story of the new hire. Going back to the prosecutor's office, the revolving door, the hallway, if you will. And let me know, do you think this statement rings true? Or how do you feel about this statement? And that's all I've got. I will do an update if I see anything from the Georgia Supreme Court about this JQC recommendation. Thanks for watching. Have a good one. Take care, you guys.